Welcome to our webinar on the European Union's new Foreign Subsidies Regulation. I'm Christopher Eukins, the Lynn David Research Professor in Government Procurement Law at the George Washington University Law School. Traditionally, and in order to advance the EU's common market, the European Union has closely regulated state aid within the European Union, limiting the types of subsidies that member states may provide to their own businesses. Now the EU has extended that state aid doctrine to contractors competing from abroad for EU member state procurement awards. To level the playing field in public procurement competitions in the European Union, the new Foreign Subsidies Regulation will require bidders to disclose subsidies that they've received from foreign governments. Bidders planning to compete for procurements in the EU, both civilian and defense procurements, will need to understand this new regulatory barrier. This is another in a webinar series, which is available on the GW Law Government Procurement Law Program YouTube page. Detailed materials for today are available at publicprocurementinternational.com, and the video from today's session will be posted there and at the program YouTube page. Please use the Q&A function today to pose questions to our panel rather than the chat function. All speakers' comments are in their personal capacity. The format for today's webinar is quite straightforward. After I share the speakers' biographies, Pascal Freton, Max Klasse, and Ramona Adder will discuss the Foreign Subsidies Regulation in detail. Our discussions, Jean Hallman-Greer, Robert Anderson, and Christian Filipic, will then address the international trade issues raised by the Foreign Subsidies Regulation and the practical implications for those competing in the EU public procurement markets. We have a very distinguished group of panelists and discussants today. Pascal is a partner at the Blomstein law firm in Berlin, is a specialist lawyer for public procurement law, a Fachanwalt für Vergaberecht, and an expert in international trade law. His public procurement law practice covers advice to both contracting authorities and bidders, in particular in the information technology, defense and security, infrastructure, energy, and healthcare sectors. Max focuses on all aspects of German and European antitrust and competition law, EU state aid, and merger control law. He's also a partner at the Blomstein firms. In state aid cases, Max has represented both companies and state authorities before the EU courts, and he was recently counsel to the German federal government before the European Court of Justice. Ramona is an associate of the Blomstein firm, and she specializes in German and European public procurement law, as well as EU state aid and subsidy law. Ramona supports both bidders and contracting authorities in procurement procedures and represents their interests in front of German public procurement chambers and higher regional courts. She advises on all aspects of EU state and subsidy law and assists the public sector as well as national and international companies in state aid proceedings before the European Commission and European courts. Jean is a principal at the Jagi Consulting Group and previously served as the government procurement lead at the U.S. Office of the Trade Representative. She is a widely consulted authority on international trade and public procurement and the author of one of the most important books in this area, the International Procurement System, which I have somewhere here, wanted to show. It's also available on Amazon, and it's really a very interesting book. Tracing the international trade agreements that the United States and other nations have entered into. It's a leading book on public procurement and international trade. Rob Anderson previously served as the lead on government procurement matters at the World Trade Organization in Geneva. He's an honorary professor at the University of Nottingham, and he regularly speaks and writes on issues of competition, public procurement, and international trade. He's a leading voice on improvement of trade and international public procurement, and like Jean Greer, a regular contributor to our program at GW Law School. Christian is a partner in Reed Smith's antitrust and competition practice in the firm's Brussels office. He advises on all aspects of EU and international competition and merger control law, EU state aid, and public procurement, as well as regulatory law. With more than 20 years of experience, Christian defends clients in state aid cases and in regulatory matters before the European Commission. With his partner, Max Scheuster, Christian produced a very useful summary of the Foreign Subsidies Regulation, which is included at the Reed Smith website and in the materials linked at the program page at publicprocurementinternational.com. As their summary points out, the FSR encompasses foreign subsidies, which may affect other areas, including mergers and acquisitions, but our focus today will be on public procurement. Again, welcome, and here I'll turn it over to Pascal.
Many thanks, Chris, for this introduction. In the next about half hour, we will give you a brief overview of the main concepts of the Foreign Subsidies Regulation, and also try to highlight some of the practical implications and problems that may be encountered in the next month. Now, just before we go into the material issues, just allow me to make a few points to start with. Now, what we're dealing here with is a brand new law, which already is in force since January of 2023. It is very broad and complex, very long, and sometimes a little poorly drafted, and it certainly adds a lot of additional red tape in many instances. So companies that are doing business in the EU, in particular those participating in public procurement procedures, will need to analyze the impact of this regulation and will need to start to prepare it for it. But having said that, there's some good news as well. The concepts in the Foreign Subsidies Regulation are not completely new. At its core, they are based on the notion of state aid law, as Chris already mentioned, which has a very long tradition and EU law. So these issues can be dealt with. It's not impossible. And also, while some of the main or most of the provisions will start to apply in July of 2023, the possibly most burdensome provisions, the notification obligations under the concentration tool and the public procurement tool, they will not apply until 12th of October of this year. So there is still time to look at that and to prepare. Yeah, we will try to give some guidance on what can possibly be done. So next slide, Chris, please. First of all, just really quick on the background, because I think that it's important to understand this, where the Commission tried to go with this instrument. Now, the Commission believes that there is a low level of international harmonization on subsidies. So in particular, the WTO agreement on subsidies and countervailing measures, according to the Commission, has a very limited effect. In addition, the Commission believes that there has been an increasing level of subsidies, in particular in state-controlled countries in the Middle East and Southeast Asia, of course, above all, China. And on the other hand, there is the state aid law regime in the EU, which puts a burden on EU companies. And whenever an EU government wants to grant a state aid to an EU company, they have to observe to that regime, and foreign companies do not have to observe to that regime. So I guess there's the fear of the Commission that these EU companies are now put at a competitive disadvantage vis-a-vis its competitors from other countries with less restrictive state aid control regimes. Next slide, please, Chris. So to fill this gap, the Commission created the Foreign Subsidy Regulation rather quickly, started in 2020, and it's already put in effect this year. Generally, what the Commission introduced in that regulation are three tools. There are two notification-based tools. One concerns public procurements, which we will focus on here today. The other one concerns concentrations, which we will also touch upon. And even out of these two situations, out of public procurements and concentrations, there still is the possibility for the Commission to look basically into all other market situations. And they created this so-called ex officio tool for that, which gives them broad powers. And As I already said, the notification-based tools, they only start to apply. So the obligations described under these tools only start to apply in October of this year. The ex officio tool already applies as of July of this year. So next slide, please. So we will now look a little bit more into the public procurement notification-based tool. First of all, next slide, please. We will look at when it applies. So first of all, there are three basic requirements. The first one is that the public procurement, the EU public procurement directives have to apply. So it has to be a contract by a contracting authority, and no exemptions have to apply. Now, there's one important thing to notice. The notification-based tool does not apply to defense procurement. But this does not mean that all defense contractors can now leave this webinar, because it is still possible for the Commission to take the ex officio tool and look at these sort of procurements. So as I said, notification tool not applicable, but ex officio tool applicable to defense procurements. The second requirement is the value of the public contract, and that's a rather high value, of course, above 250 million euros. Again, if you now decide to leave this webinar because you never participate in procurement procedures that are this high, I urge you not to do that, because again, under the ex officio tool, it is possible for the Commission to look at public procurements below these thresholds. And also there's a hidden provision, and I'm thinking about Article 29, paragraph 8, that at least as I read it, allows the Commission to also look into all procurements under the threshold, and to require a notification and possibly even initiate an exclusion procedure if it's below these thresholds. It remains to be seen if the Commission makes use of that, and it's very, very hidden in the regulation, but it's still a possibility. Now, the third and final requirement, and we will talk about that in the next, a little more in the next slides in detail, is the requirement that the financial contribution that the bidder received by a certain third country has to be above 4 million euros in the last 3 years. And what is important to note is that this does not only apply to financial contributions that are made to the bidder, to the entity that is taking part in the procurement procedure as a bidder, but it also applies to holding companies, to subsidiaries. So basically the whole corporate group is covered by that, and the relevant amount has to be gathered by looking at all the different financial contributions made to these group companies. In addition, also main subcontractors and suppliers are covered, and which is in particular the notion of main supplier and subcontractor is defined in a very vague way. So it is extremely difficult with these far-reaching provisions to circumvent this notification obligations. So I guess the Commission made sure that there's really no possibility to go around it. So next slide, please, Chris. Now that we've established the thresholds, the question now is, what is financial contribution? Again, this term is defined extremely wide. So transfer of funds or liabilities is covered, capital injections, grants, loans, guarantees, what have you. Also, the foregoing of revenue that is otherwise due is covered. So even tax exemptions could possibly be covered by that. And finally, even the provision or purchase of goods and services. So even government contracts, public contracts, could be covered by the term financial contribution. So it's clear that this is a very broad term, and and I want to make that clear, and it's not limited to subsidies. So it's just it's one element of the definition of subsidies, which we will go into in a minute, but it's a lot broader. And of course, it's not only relevant to determine the applicability, but it also is relevant in terms of what you have to actually notify. What information do you actually have to give to the Commission? And we will come to that in a minute. But if that's not enough, Chris, next slide, please. The FSR does not only contain a notification obligation, it also, in all other cases, as the Foreign Subsidy Regulation says, it also contains a declaration obligation. And the question here really is, when does it apply? Because the law says in all other cases. What does that mean? I think there are two instances where it is rather clear what is meant. The first one is that this declaration obligation is not applicable to procurements not covered by the procurement directives, and it's also not applicable to defense procurement. It is clearly applicable to procurement procedures above the value of 250 million and financial contributions that are below the 4 million threshold. So in that case, it's clear that there's a declaration obligation, but the wording in all other cases could also be read as meaning that it applies to all procurement procedures under 250 million, which would be basically all procurements above the EU thresholds, which you all know are a lot lower than the 250 million. I don't think that it's meant that way, and I think there are arguments to say that that's not what the Commission aimed at. But it's from the wording, it's still possible to argue this way. Next slide, please. Now we talked about the applicability of the notification and declaration obligations, but the question, of course, is what actually do you have to notify or declare in your offer to the Commission, and that is shown on this slide. I will not go into the details. This is just to show you that there's a different amount of information and a different level of detail that needs to be provided if it's a notification or a declaration obligation. Also, please note that this is still in the making, as these exact information that you have to give to the Commission, they are governed by the implementing regulation, which is still in the making. So this still may change. And as I said, these obligations, these notification declaration obligations, they apply from 12th October 2023. Now on the next slides, Ramona will go into the details of what the Commission actually intends to do with all that information that it has gathered now under this notification and declaration tool.
Thank you, Pascal. So after having received the notification, the Commission opens a two-stage review procedure. Firstly, there's a preliminary review. The Commission examines whether a foreign subsidy exists and whether there are sufficient indications that it distorts the internal market. If this is the case, the Commission opens an in-depth investigation. In it, it further assesses whether a distortion exists, it carries out a balancing test, and it examines any commitments by the company concerned. I will now explain these 4 steps in further detail. Next slide, please. As mentioned, the Commission firstly assesses whether a foreign subsidy exists. There is a definition of a foreign subsidy in the Foreign Subsidies Regulation, which is copied in here. It has 4 main elements. The first element is a financial contribution, which Pascal has already explained before. Secondly, the financial contribution must be provided by a third country. This means that it is directly or indirectly attributable to the state. Therefore, financial contribution is not provided by a third country if the money fully stems from privately owned sources. The third one is the most important criterion. The financial contribution must confer a benefit. This is the case if the financial contribution could not have been obtained under normal market condition. This criterion therefore limits the foreign subsidies definition to actual government support measures like grants or loans with an interest rate below market terms. On the other hand, it excludes any payments by the states under a contract awarded in a competitive procurement procedure. Last but not least, the financial contribution must be selective, which means that it is limited to one or more companies or industries. Therefore, a general corporate tax reduction that applies to all companies does not qualify as a foreign subsidy. Next slide. If a foreign subsidy exists, the Commission examines whether it distorts the internal market. The Foreign Subsidies Regulation defines certain categories of subsidies that are most likely to distort the internal market. For example, subsidies granted to an alien undertaking. Furthermore, categories of subsidies are defined where a distortion is unlikely or where there is no distortion. For example, subsidies that are below a certain threshold. However, for most of the cases, an individual assessment is necessary. A distortion exists where a foreign subsidy is liable to improve the competitive position of a company in the internal market and actually or potentially negatively affects competition in the internal market. As these terms remain very vague, there's significant uncertainty for the majority of cases, and the Commission has a very broad discretion whether it comes to the conclusion that a distortion exists or not. Next slide, please. If the Commission comes to the conclusion that there is a distortion, it may carry out a balancing test. In this balancing test, the Commission may balance the negative effects of a foreign subsidy in terms of distortion against the positive effects on the development of the subsidized economic area in the internal markets. Positive effects may relate to all EU policy goals, for example, environmental protection. Also, with regard to the balancing test and in general in its assessment, the European Commission has a very broad discretion. We assume that when exercising its discretion, the European Commission takes existing state aid case practice as a benchmark. In this regard, it is worth noting that the EU has currently relaxed its state aid rules. The relaxation is also seen as a response to the US Inflation Reduction Act. It is likely that the Commission takes this new and less strict approach under EU state aid law into account also when assessing foreign subsidies, meaning that there is more leeway also for foreign subsidies. Next slide, please. After the investigation procedure, the Commission makes its decision. If the Commission concludes that there is no foreign subsidy or no distortion, it adopts a so-called non-objection decision. This allows the contracting authority to award the contract to the bidder under investigation. If there are foreign subsidies that distort the internal market, the company under investigation has the possibility to prevent exclusion from the public procurement procedure by offering so-called commitments, for example, repayment of the subsidy. If the Commission considers the commitments offered by the company sufficient to remedy the distortion, it adopts a decision with commitments. If foreign subsidies exist which distort the internal market and there are no sufficient commitment, the Commission prohibits the award of the contract to the company under investigation. The decision of the European Commission is binding for the contracting authority in the member state. Furthermore, for the Foreign Subsidies Regulation to be effective, contracting authorities are generally not allowed to award the contract to a company under investigation until the Commission made its decision. Next slide. This was, in a nutshell, the notification-based public procurement tool. As Pascal mentioned in the beginning, the Foreign Subsidies Regulation has two other tools. One is the general investigation tool, also called ex officio tool, which allows the Commission to investigate foreign subsidies in all other market situations. If the Commission decides to open an investigation under the general tool, the procedure is pretty much similar to that under the notification-based instruments. I will not go too much into detail here, as the relevance of this tool is expected to be limited. However, I will touch upon some points that are particularly important with regard to public procurement. Next slide, please. In view of public procurement procedures, it is worth noting that the general investigation tool does also apply to security and defense procurements, which are exempted from the notification-based tool. However, contrary to the notification-based tool, such reviews and the general tool are limited to awarded contracts, and very important, they may not result in cancellation of award decisions or termination of an already awarded contract. Instead, the Commission has the possibility to adopt a decision with redressive measures. Redressive measures can include, for example, repayment of the subsidy. Thus, also, this general tool can be very, very powerful. It remains to be seen in which situations and to what extent the Commission actually makes use of it alongside the notification-based tools. This was a brief look into the ex officio tool. I will now hand over to my colleague Max to explain the third tool that applies to concentrations.
So if we move on to the next slide, please. Just to round this up, the third pillar is the notification requirement for concentrations above certain thresholds. Again, the purpose is to filter out those transactions which are potentially infected by foreign subsidies, and concentrations trigger a notification requirement under the FSR if two cumulative thresholds are met. There's first the turnover threshold, which is met if the aggregate sales of the target company exceed 500 million euros in the EU. And under the financial contribution threshold, a notification is required if the companies involved were granted combined aggregate financial contributions above 50 million euros in the 3 years preceding the transaction. If met, the transaction has to be notified to the Commission and must not be implemented prior to clearance. The good news is that the deal threshold 500 million is relatively high, approximately twice as high as the corresponding threshold under the merger regulation. That means that transactions covered by this threshold are typically also notifiable under the EU merger regime, which is then subject to a separate filing. So you have the one-stop shop with the Commission, but two completely separate and independent proceedings. The Commission has estimated that approximately 40 to 50 transactions per year will exceed that threshold on the basis of the merger notifications they have received in past years, and that only a smaller chunk of these 40 to 50 mergers will then also be notifiable because they meet the second threshold. However, as explained by Pascal and Ramona, the broad notion of foreign financial contribution may make it difficult to sort out whether this 50 million threshold is exceeded or not, and the devil will be in the details. And just to be very clear, the notification requirement and the information needed to establish whether the requirement is triggered is completely unrelated to whether to the substantive test under the FSR. That means that even where it's very obvious that a financial contribution the acquirer has received does not facilitate a given transaction, or where there's clearly no link between a certain contribution and the acquisition at stake, the notification requirement may still kick in. And if that wasn't enough, the European Commission also has the power to request notifications for sub-threshold mergers, transactions where it suspects that the companies involved have received foreign financial contributions that amount to subsidies. If we could move to the next slide, please. This obviously has important implications for deal planning. It's an additional process that comes on top of merger filings and FDI filings, but has completely different requirements. That means that the lead time and prep time will not only depend on deal complexity and substantive issues, but also on the availability of information and data required to prepare the notification under the FSR and to engage in pre-notification discussions with the Commission. We have listed a few of obvious points to be considered in the deal planning and when negotiating the sales contracts. For further consideration, in the interest of time, I won't go into the details, but we could move to the next slide. And next slide, please. So to wrap up, a quick look at the timeline. Pascal mentioned it, the FSR entered into force in January. The substantive provisions will enter into force in July. But the notification requirements for bids in public procurements and the transaction tool will only apply as of 12 October this year. With the draft implementing regulation, there is some guidance on the notification, on the details of the notification and the requirements and the information to be submitted to the Commission, and that's in the making. There's no guidance so far on the substantive test. There's very little description in the regulation itself. There's no guidance in the implementing regulation. And that will only come at the beginning of 2026. So the regulation says. We understand that there is some hope that the Commission could be quicker than that, but any further guidance on the criteria for determining the existence of a distortion and the balancing test so we have to wait further for this. Then next slide, please. So what does all this mean for US companies? The signals we're receiving from the Commissioner, Ms. Vestager, they are mixed. So on the one hand, she says review of US subsidies will be the absolute exception. So some comfort here. But on the other hand, she says subsidies that are given in the US will be relevant to notify in the EU. And both is true. So there is no general waiver for US companies. They are, if they meet the thresholds, if the thresholds are met, then they have to go through the burdensome filing process. And again, as Ramona pointed out, not only tax breaks under the Inflation Reduction Act, but given the broad notion of foreign financial contribution, basically all sorts of dealings with the state and from federal level to very local level can be covered and add to the foreign financial contribution and thresholds set out in the FSR. Hence, preparation is key to cope with the additional information required for relevant declarations and notifications. Whether the FSR will then actually lead to US companies being excluded from procurement procedures, or transactions being prohibited is another question and remains to be seen. And that's will essentially hinge on how the Commission uses its broad discretion in particular in the application of the balancing test. The Commission seems to be well aware that a too broad or too strict application of the FSR could also negatively impact competition on EU procurement markets and M&A markets. As Ramona said, also the relaxation of the EU state aid regime under the EU's Green Deal industrial plan will have an impact on the assessment, because what's quite clear is that the Commission will not be able to prohibit something which is not prohibited in the EU. If we then move to the next and final slide. So is there any hope? The FSR has triggered a lot of criticism from stakeholders, including from, I have to say, from EU companies, international, beyond the EU, active EU companies, i.e. the very companies the FSR is meant to save from unfair competition from foreign finance competitors. In the draft implementing regulation, the Commission is looking for pragmatic solutions. So it has made clear that companies can get waivers for certain types of information if it's clear that the information is not required for the assessment, for the substantive assessment. And also there are certain de minimis thresholds for smaller amounts of individual aid, which are very low, so in the 200s or 400,000s. This is certainly welcome, but it and may save some time when filling out the notification forms, but still it will be an enormous burden when you go through the process, because the main problem persists that a lot of the information is not required for the notifications, is not readily available, and has to be collected upfront before you can even engage in a meaningful discussion about whether you can get a waiver for this or that information. So the quantity of information required for filings is clearly absolutely massive, and often unrelated to the deal complexity and any substantive issues. May the criticism make the European Commission rethink? Now that the FSR is the law, there are clearly limitations to what the Commission, even if some in the Commission may regret what they have done, there are clearly limitations to what the Commission can do about it. So for the time being, one can be seriously concerned that the procedural burden will mean that global companies, not only US, but also EU companies, are disadvantaged in public procurements and M&A transactions, even in cases where it's very clear from the outset that the effects of the FSR, the FSR wants to target, are very unlikely. I'll leave it at that for now so that we can have a meaningful discussion and hand back to Chris.
Thank you very much. That was an excellent presentation. Our colleagues at Wilmstein, thank you all very much. I have the happy news. If you look at the participants, you'll see that many of our participants are in fact fellow academics from around the world. Just want to share. I've found Jean's excellent book, The International Procurement System, which is an outstanding trade book, as I referred to before. I did want to just cite it. I want to emphasize the book not only because of its wonderful content, but the way that Jean published it. Jean published it through Amazon, and it's very affordable for our students, and a number of our students are participating as well. So many thanks to Jean for serving as a pioneer in reforming academic publishing. So we want to have a discussion now. Thank you very much to the Blomstein folks for allowing sufficient time for discussion. I'm going to turn it over first to Jean Greer to talk about some of the issues in transatlantic trade that have triggered what is arguably a protectionist impulse on the part of the European Commission, or certainly helped frame this new FSR. Jean?
Thanks, Chris. Growing protectionism in the United States is impacting the transatlantic trade relationship. 3 laws enacted by the US Congress in the last 2.5 years, with the strong support of the Biden administration, embody the largest set of US industrial policies since the New Deal. They are the Infrastructure Investment and Jobs Act of 2021, the Inflation Reduction Act of 2022, and the CHIPS, or Creating Helpful Incentives to Produce Semiconductors and Science Act of 2022. Through these measures, the US seeks to boost US manufacturing through stringent Buy American requirements and subsidies to select firms. I'm going to discuss in just a brief detail the first 2 of these laws. First, looking at the Infrastructure Investment and Jobs Act. This law significantly expanded domestic preferences for infrastructure projects, particularly at the sub-federal level. Under the Act, U.S. produced iron, steel manufactured products and construction materials must be used in every infrastructure project receiving federal funding. Most of the projects are undertaken at the sub-federal level. The Biden administration has broadly interpreted the law's requirements to maximize its application. While the law allows certain waivers of the Buy America preference, the Biden administration is actively discouraging the use of waivers. The law's preference does not apply to projects covered by international agreements, such as the WTO Government Procurement Agreement and a bilateral US-EU agreement. However, the Biden administration has downplayed this statutory provision and did not make any provision for its application when it issued proposed guidance on the law's implementation in March. The European Union singled out this omission in its comments to the Office of Management and Budget on the proposed guidance. Turning now to the Inflation Reduction Act, which is the one that's getting the most attention right now. This act provides the single largest climate investment in US history, and it puts the US on a path to reduce its carbon emissions by roughly 40% by 2030. And so that's good news. And European officials have welcomed the IRA's climate goals, but criticized the discriminatory local content provisions and its manufacturing subsidies amid fears that the incentives might induce European firms to shift their production to the US. Of particular concern is the IRA's tax credit of up to $7,500 for buyers of new electric vehicles, if materials such as critical minerals for those cars' batteries are sourced in either the US or one of its free trade agreement partners, or if the electric vehicles is assembled in a North American plant. The Treasury Department has, in implementing the IRA's provisions, is seeking a means of addressing the concerns that the EU, Japan, and other trading partners without FTAs with the US could take advantage of to obtain access to the tax credits. And it's proposed a broader definition of free trade agreements than is traditionally used. And this is actually creating some concerns in the Congress. And what it has done is, in a proposed regulation that was officially published yesterday, April 17th, Treasury set out criteria for this broader definition of FTAs and focused on agreements that provide for critical minerals used in EVs, electric vehicles. It specifically cited a recently concluded agreement between the US and Japan as meeting these requirements. That agreement is aimed at ensuring that the critical minerals assembled, is aimed at ensuring trade in critical minerals. It includes commitments to not impose duties on exports of these minerals essential to the EV battery supply chain, as well as a commitment to confer on investment in critical minerals that may affect national security. It also provides detailed undertakings related to the enforcement of labor and environmental laws. The US and the EU are engaged in negotiations on a similar critical minerals pact that would allow EU companies to benefit from the tax incentives. At this point, the negotiations are ongoing, so we don't quite know when they will conclude. The EU is also seeking ways or flexibility on the IRA's local assembly requirement. And in the interest of time, I'm going to stop here. Thanks, Chris.
Thanks very much, Shane. I'm going to turn it over to Rob to discuss some of the, and these are some of the issues that are framed on the publicprocurementinternational.com program page. I'm going to turn over to Rob to discuss how the FSR may collide with the WTO agreements, specifically the government procurement agreement and the subsidies agreement. Rob?
Thanks very much, Chris, for your introduction, for organizing this extremely interesting session, and to our colleagues from Blomstein for their really excellent presentation. Indeed, as you've said just now, and you rightly point out on the Public Procurement International webpage for this webinar, there are important issues to ponder concerning the relationship between the Foreign Subsidies Regulation and various WTO agreements. In particular, I will speak to the Subsidies Agreement, also called the Agreement on Subsidies and Countervailing Measures, or the SCM Agreement, and the WTO Agreement on Government Procurement. And in broad terms, and again, I urge panelists, or I urge participants to look at the materials on Chris's webpage. In broad terms, I think we have to ask, and that's the way I'm putting it. That's the way Chris puts it on his webpage, not as definitive answers, but as questions to ponder. I think we have to ask how the FSR exists in the broader context, first, of the subsidies agreement. And indeed, is it possible that the powers and processes which have been outlined by our colleagues from Blumstein potentially go beyond the limits of the WTO SCM? And I'm not saying that they do. I think this is an issue on which we all need to reflect, and on which, undoubtedly background discussions are going on even now in Brussels and Washington, and I think, and potentially Geneva. And I think that's very important. And the other point is an interesting one concerning the GPA, the Government Procurement Agreement. And here it really is, because the GPA, people may or may not know, does not exist only to support cross-border bidding on major procurement contracts. It also exists to ensure non-discrimination with respect to the operations of local affiliates of foreign corporations, in particular those from GPA parties. And a question it exists as to whether the burdens that are imposed concerning notification, for example, will have the effect of putting foreign affiliated corporations operating in the EU procurement markets at a disadvantage vis-a-vis EU. And I think we have to think about that from this, and we have to inform ourselves and to give better reflection to these issues. Now, I would like to end by saying what I think is going on in broad terms. I think that the EU believes that the current WTO framework for addressing foreign subsidies is inadequate. I think they believe this in light of developments and current trends in one or more Far Eastern country that we can all think about. And I actually think that they're right in this broad perception. And I think that without diminishing concerns that will exist as between the US and the EU with respect to the application of the FSR, and as Jean points out, also potentially with respect to recent US legislation, despite that, there is potential common ground here. I think that a number of people in both Brussels and Washington are coming to the conclusion, and I share this, that the global instruments and frameworks for control of subsidies need to be updated and revised. And I would go even further and say also the GPA needs to be looked at again now, more than 10 years after the recent renegotiation, what we used to call the recent renegotiation in 2012, needs to be looked at again, and with respect to issues concerning its coverage and application to environmental green procurements and that kind of thing. So I think that in the short run, we are rightly, and the presentation is rightly looking at questions of application and concerns about paper burden, which I can see are significant. And I think in the longer term, we are accumulating a body of concerns that needs to be and can be discussed in further multilateral negotiations and in bilateral negotiations between the EU and the US. And I think, so I'm not, so I hear clearly the concerns that our Blomstein colleagues have raised very effectively concerning the various requirements of the FSR. Those are certainly relevant. But I also have an underlying degree of sympathy with the intention here. And I think the trade community is increasingly of the view that we need to have a new framework for looking at subsidies and countervailing measures in international trade. And I think that's right. Thanks very much.
Thanks very much, Rob. So we have about 10 minutes left, and I want to turn it over to Christian. Christian, the materials that we accumulated on the program page, many of the materials from the law firms talked about preparing for the FSR for both you and our colleagues at Blomstein. When should companies that are going to compete for European procurements, when should they start preparing for the FSR, and how should they start preparing? What do you recommend?
Yes, thanks a lot. Thanks a lot, Chris, for the question, and thanks a lot to my colleagues from Blomstein, and also to my other colleagues for the contributions. First, when should they prepare? The best is yesterday. So I think preparation is here key. But before I start about the preparation and the next steps, I think I would like to give some additional comments on the view of FSR from the EU perspective, from the perspective from here out of Brussels. I think what is super important, and Rob has also said it before, why is Europe doing that? Why is the Commission doing that? Europe at the moment needs a lot of investments, needs a lot of goods from outside, needs a lot of money, but very often we get the investments from some jurisdictions which are not always following the same rules as we are following. It might be China, it might be also like the Middle East, where a lot of companies are controlled by sovereign wealth funds or by authorities or by governments, and do not always follow 100% economic rules. So the overall idea is to create, as also Pascal and Max have said it very clearly, to create here a very clear level playing field, also for all companies participating and who want to do business in Europe, but also for all European companies. So there should not be an advantage for neither companies outside the EU nor for companies acting within the EU. Everyone should follow the same rules. And in order to do so, the European Commission has here created a very clear set of rules, and they're very clearly implementing those rules, and which are complementing the existing rules on merger control, on FDI, foreign direct investment, which is our CFIUS regulation, on regulatory rules, and on the state aid rules. And here we had a clear gap on state aid, and the idea here was to close that gap in order here to create a level playing field. And very important here, what is the role of the US, and to which extent the United States might be triggered? Yes, it might be triggered, because at the moment, this is the big fear of the European Commission, we are in a very difficult environment. We have got a transition of our economy. We have got the Green Deal at the European, which is very important for the European Commission, where we've got the transition to sustainability, to green ways of doing things. We've got the problem with the energy transition at the moment. We've got the digitalization of our market. So it's a lot of things which are changing, and at the same time, due to the energy crisis. We're in a financial crisis at the moment. And before, we're just getting out of the COVID crisis, where a lot of companies were in difficulties, and a lot of governments, even in the US, were responding to those difficulties. And I remember, and I think they were already mentioned before, if I consider here the Inflation Reduction Act in the US or the CHIPS Act, where a lot of companies had access to funds, also like from the public. And the European Commission wants to respond here. And one thing is super important here, that the European Commission is very, very determined in its action. Even if you look at the speed, how fast here the FSR was like introduced and put into force is really like outstanding for European standards. Also something which is very important here, and that's all important when considering for a stakeholder in the US, am I concerned, is like the new political environment. We have got a clear shift of powers also like towards Brussels on many things. Member states are not that strong at the moment, and a lot of regulatory intervention, a lot of politics and policy is now taken over by Brussels and by the European Commission. And here also, like with the FSR, there's a very clear tool introduced where the absolute power in order to look at that and the competence to look at that is at the European Commission at DG Competition. I think it's mainly DG Competition here. And in addition to that, what the European Commission has also like created is like a powerful tool, because the Commission has got a lot of powers like to take decision, as Ramona has mentioned them before. They can make a decision, a prohibition decision, but they also can impose quite substantive fines for companies. They have also like investigation tools. It's quite a powerful tool here. And some people are saying that the Commission has created here really a tiger with teeth that really can here implement the somehow political, but also like economic interest and ensure overall that it is like there's a level playing field for all companies. So coming back, Chris, to your question on the preparation, we have heard before we've got notification requirements, and in order to submit those notifications, and we have got at the moment we get also like the guidelines and all the preparatory documents are prepared at the moment. There are a lot of documentation and a lot of information which need to be collected, and that will take time. And here preparation is key for every company, how to prepare for that. And you know, on the one hand side, we have heard the term financial contribution. Financial contribution, you have to go back for a couple of years and look at all different advantages that the company has received in what form soever in the past. It can be like the acquisition of a building below the value, or like a guarantee without any commission or any or under market terms. And the difficulty here is not only like to collect that information, is also like to interpret the financial contribution under the EU rules, because you have to follow here the EU rules, how the financial contribution is to be assessed. And here's also something very important, and I want to underline and completely echo what I think Max has said here before. It's completely different. We have got no rule of reason here. It's not that you have to see was the contribution which perhaps didn't affect the market. We are first looking at the financial contribution, just to look at that in the first step, and then afterwards we are looking to which extent that contribution is perhaps not at market terms, to look to which extent it might distort competition, it might have an effect, and only at the end, in different steps, to see if there's like a balance test to be made. But first is like to see if has there been a contribution, and that is already sufficient to trigger the rules. And here important, and all that needs to be prepared beforehand. And then we have also like addressed before, and this is also something for me is super important to consider, are all those activities below the threshold. So no company, no stakeholder should ever think when I'm below the threshold, I'm perhaps out, because maybe there's like the ex officio possibility, but also like you might have to ask for questions. And here I would like to remind that companies, when participating in a tender and when they're below the threshold, as my colleagues have pointed out before, they need to give like a declaration that they're below the threshold and they're not triggered by the notification requirement. But it is not enough to write here the two-liner, I'm not fulfilling those criteria. You always need to have the backup for that one, because there might afterwards come the question, why are you not required? Because from public information, we know A, B, C, D, and there might come question, and there might be questions. So it is also very, very important whenever you look here at when you're participating in a tender and you believe that you're not maybe caught by the notification requirement, to have also like prepared very, very well why that notification requirement is not why that no notification is required and why I'm not fulfilling the criteria. And the same applies to merger control. We have got merger control proceedings where you have got also like to make beforehand a notification and you might be below the threshold. But I would like to draw your attention that in parallel, you might have a merger control notification under competition rules, so not under foreign subsidy rules. And there's also like a question in there, in the so-called Form CO in Europe, which is asking, did you receive any contribution from a government, from a government or from a public source? That information might be afterwards passed on also like for the directorate, for the team, for the unit dealing with the foreign subsidy regulation. And if you have provided here information on the merger control requirement, automatically it will also like trigger here question whether or not you have made a filing under the foreign subsidy regulation. And the last point that I also would like here to make is like a pre-notification. We have discussed about that before, and there's like an interesting possibility that was granted here to companies, to stakeholders, that you can go to the European Commission before you do the filing and discuss with them in the framework of a pre-notification whether there's a waiver for certain information or which kind of information need to be provided, or maybe to clarify the one or the other issue. However, we have got the same tool in merger control. And here it is very, very important that whenever you go to the European Commission for the pre-notification and open pre-notification discussion, that everything is already prepared. This should already be for the company like the end of the filing, because you cannot go just to the Commission and discuss, maybe I am, maybe I'm not, because whenever you say something, it's like carved in stone, and you're like creating like problems there. So I think it should be here a very clear final filing that you give to the Commission, giving more or less the Commission the opportunity, like to have a look if they want to know something more or have some additional information. But it is not like for the companies upfront a discussion forum. I think that is very important, like to see what kind of information that we want to provide or not to provide. Of course, you can ask on certain things like for waiver, but you should have a very, very, very clear position. And the other point is here where it's very important to be well prepared, that the pre-notification procedures do not know any time frame. So is here like the Commission is not linked to and limited to any time frame, which is also like a very, very important. So all that, considering all that, I think it is very important that at least going back to all the period, like at least the 3 years period where you have to collect information, that you always keep track of financial contributions that you have received, in particular when you start doing business, that you really have consider from the beginning on this new foreign subsidy regulation, and what are here the kind of information that you need to prepare, because that collection, that pre-thinking will help substantially to make afterwards the filing requirements, the notification requirements, and all the proceedings here with the European Commission maybe less burdensome and less complicated than it would be when you are not really prepared. I think that one was like some general statements, like with respect how the Commission might see it, how it is seen from the European from the process perspective, and some also like consideration with respect to the preparation of any filing requirements. I hope I managed to give a good overview on that. Back to you, Chris.
Excellent, Christian. Thank you very much. Just want to wrap up. I want to give the Blomstein folks and Jean and Rob an opportunity for last word. Just a quick question for the Blomstein folks that if the state aid doctrine, the normal state aid doctrine, does apply to the Foreign Subsidies Regulation, if your notification requirements are shaped by the state aid doctrine, there's huge exemptions under the General Block Exemption Regulation, the GBER, which is linked on publicprocurementinternational.com. Well, there are huge exemptions from that state aid doctrine for certain types of expenditures by member states. Will those exemptions apply as well to the alleged foreign subsidies by foreign governments? That's a very important technical question for U.S. contractors that might, for example, be competing in the European Union. That I'll turn over to the Blomstein team.
Yes, that's actually a very good question. And I think the answer is yes and no. It will have an impact on the yes, in terms of you won't see an intervention. If something is covered by, if an EU aid would be covered by the General Block Exemption Regulation, you won't see an intervention by the Commission if the similar aid was given in the as a foreign subsidy outside of the EU. So that's very clear to my mind. But on the other hand, it doesn't mean that you don't have to notify under the FSR. And that's the big problem, that's also a very important difference between the FSR and the state aid regime as we have it. State aid has basically the same conditions as a foreign subsidy. So you have the 4 requirements, including selectivity and benefit. And only if you have all the requirements, often it's very difficult to establish whether you meet the requirements or whether there are certain exceptions, and something which looks like a benefit is not a benefit under the case law, and so on and so forth. So there are all sorts of difficult questions. But if at the end of the day you're comfortable with the decision that there is no aid involved, there is no notification requirement, and that's very different under the FSR, because for the FSR you only need 2 requirements, and that's the foreign financial contribution, irrespective of whether it confers a benefit on the recipient. And so the answer is, even if you're covered by the General Block Exemption Regulation, and at the end of the day won't have a problem because you will get clearance, you still have to notify and get through the burdensome process.
Thank you very much. Jean and Rob?
Jean?
Yeah, I have nothing to add. Thank you.
So thanks very much, Chris. I have 3 points that I want to make. First of all, it should be clear, and it should be noted here, that it is not the case that no thought is being given to interactions between the FSR and broader international agreements in Brussels. On the contrary, it's clear that some people in Brussels are thinking about these things in an interesting way. And one indication of that is this provision, I believe it's in Article 44.9 of the FSR, to the effect that measures shall not be maintained, relevant measures shall not be maintained where these are contrary to the European Union's obligations under international agreements. And I have to say, this reminds me very strongly of the language that we've also seen in many US statutes now, including, but certainly not limited to, the 2009 Recovery Act, where the US implemented these strong Buy American provisions, but included that language in, I think it was section 1605D, that says the foregoing shall be administered in a way that is consistent with US obligations under international agreements. So people are aware of these potential broader interactions. But having said that, I think our colleague Jean, you made an important point earlier, that we probably need some guidance on and I think there is some guidance that is missing on giving effect to these provisions, which are intended to ensure no conflict between these internal measures, internal in some sense, and WTO agreements. And further to that point, actually, I think, as I understand it, there's a interesting proposal by the U.S. Chamber of Commerce to the effect that, if I understand correctly, that companies from parties to the agreement, the WTO agreement on government procurement, should potentially be given exemption from some or all of the requirements of the FSR. And I'm not here to sort of plug for that. I think it would need to be thought through carefully. But I think it's an interesting proposal. And I think the global community should be thinking of ways to, in general terms, to deal more effectively with problems of international subsidization, which are real, at least to an extent, but at the same time ensuring that undue burdens are not imposed on companies, and maybe especially from companies from countries that have committed themselves to the framework, the kind of framework that you see in the GPA. So I think that's just an interesting idea to consider. And my last point is something we've alluded to all along in this wonderful webinar, but haven't said explicitly. But I think one of the insights that comes out of the discussion for me is the potential relevance of the existing EU state aids framework, or elements of that framework, because on the global stage. And I think that this is a kind of further thought that merits conversation. It's a deep thought. I'm certainly not saying the EU system could just easily be translated holus bolus to the whole world, but I do think that there may be elements to the EU framework for state aids, particularly the competition-based elements to that framework, that are potentially, that merit reflection on their possible broader use in international and world commerce. Thanks ever so much for organizing this wonderful discussion, Chris.
Thank you very much, Robin. Thank you very much to all our guests today. This was really an excellent webinar and a very important introduction to the FSR, to the Foreign Subsidies Regulation. Thank you all again for joining us, and have a wonderful day. Take care. Bye-bye.
Yep. Thank you.
Bye.
Thank you.